Hi, I'm Joe Chilling, mornings from 7 to 9 at Buffalo's oldie station, the Big Wack. Joining us on the Big Wack's Buffalo on the Rise today is Vincent LoTempio. Vincent, you know, I guess when I think of you, I think of patents and trademarks and things like that. And that's actually what you are. You're a patent attorney, correct?
That's correct. I'm a registered patent attorney. I've been doing this for like 25 years. And yeah, there's a very limited number of attorneys, you know, in the country that are able to practice federally throughout the whole entire country by having this designation as a registered patent attorney. It's one of the few attorneys that you can claim to be an expert in.
Do people oftentimes, you know, come up to you and say, what the heck is a patent? I mean, you know, we hear patents, we hear trademarks, we hear service marks, right? To me, it's like, you know, alphabet soup. I mean, you know, but they're very specific to whatever you want to do, right? There are certain areas where these things stand out.
Absolutely. And even, you know, attorneys call me and says, I have a client that needs a copyright or needs to register their trademark. And then when I get them on the phone, it's completely something different. So even attorneys don't recognize the difference. You know, basically, I use the Coca-Cola bottle as an example of the different types of intellectual property. If you were the first caveman to invent the bottle, you can get a patent on the utility of how it works. It's a container that holds a liquid that's easy to drink from. And if you wanted to sell that bottle, you could put your trademark on it, which your trademark would be Coca-Cola, the symbol, and you'd put your little R, and that would be your trademark. And you could argue that it's a work of art, you know, and copyright is for works of art like paintings or songs. It's a work, right? Or books, you know, so copyright protects those type of things. So yeah, patents are for useful articles, trademarks are brands, and the copyright is for works of art.
What about, you know, you bring up a thing with regard to a Coke bottle, okay? Now, Coke, you know, you think about Coca-Cola and what makes the whole thing up, you know, right? The ingredients and all that. The bottle has a certain shape to it. It's not just a straight glass bottle or whatever, plastic bottle. Can you trademark that actual shape?
You know, that's a great question because, yeah, that's another reason why I use the Coca-Cola bottle as the example. In 1963, they registered it as a trade dress, the look of the bottle. And you can register a patent as a design, just the look of the bottle. So they could have registered the Coca-Cola bottle as a patent, a design patent. So you can make any bottle you want, you know, and bottles have been around forever, so you can't stop people from making a bottle. It would be nice if you can get the patent to stop them from using a bottle, but Coca-Cola can stop you from making their bottle, you know, look like their bottle by trade dress or by a patent, a design patent. So if you have the new Gatorade bottle or the bottle of, you know, the Poland Springs bottle, in your mind you're picturing what these bottles look like, you can protect that shape. Yeah, that's a great question.
What about Kleenex? Kleenex, I mean, they refer to any kind of tissues as Kleenex now, right?
Yeah, so that would be a generic trademark, like aspirin and escalator. Those start off as trademarks, you know, and even like, what's the new one with the roller skates, rollerblades, right?
Yeah,
so they'll say, go get I want an inline skate, or go get me a box of tissue. Your mother tells you to go to the store and buy this box of tissue. So you might come home with Scott tissue or Kleenex, but if she says, get me a box of Kleenex, you still might come home with a box of Scott.
That's exactly right.
So you'd want her to say, get me a box of tissues made by Kleenex. And that's how you should use your trademark when you're advertising it. You don't say, buy a Kleenex today, buy a box of tissues, buy Kleenex today.
So someone in the Western New York area wants to, you know, do a patent or trademark or whatever. What's their first step? What should they do and what should they be thinking about?
Well, I always say, don't tell anybody first, right?
Yeah, that's a good
You know,
point.
we want to keep it secret. And even like the inside the Coca-Cola bottle, it's a trade secret. How is it made? They don't tell anybody how it's made, right? So the patent, you certainly want to, you know, keep it secret. You want to be able to search to see if anybody else has it, and that's why you hire me to do that, and we could do a search to see if it's out there. You want to see what your competition is doing and see how how you're going to compete with them. And it's certainly the first steps. And I always say it's a long journey, right? the proverbial 2,000-mile journey of, it starts with the first step.
Right.
And I always say the patent is the first step in the 2,000-mile journey. If you're walking from New York City to Los Angeles, you're just getting off the George Washington Bridge into New Jersey. There's so many things that you have to figure out to market, distribute, and to manufacture the product. So, the patent is one of the things out of many that you have to do to be able to get that product out of your head on all the shelves in Lowe's, or Walmart.
But they should call you. That's kind of like the first step. I was thinking, years ago when people were wearing jeans that were ripped.
Yeah.
The first person that says, "Oh, I get a rip in this jean. Oh, you better throw these out." And then they said, "Oh no, that's an idea. We're going to patent ripped jeans," or whatever the case may be. So if somebody has an idea like this, they shouldn't necessarily think, "Oh, that's foolish." They might call you and say, "Hey, is this worth talking about?"
Yeah, and I'm not sure if we could market, obviously, because I was all over the world and I've seen kids with holes in their jeans and they're still doing it. You can stop somebody from ripping a hole in your jeans. I don't think that would be kind of difficult. I always use the example you see when it came out with the girls would have on the back of their butts the word pink, on the sweatshirts. Yeah. I'm like, I wonder if they could do that. So the word pink is like the trademark and you can stop them from doing it. Maybe if you put something else there, but to be registerable as a patent, it has to be new. No one's ever done it before. And certainly there's been ripped jeans forever, so I don't know if you get past that one. It has to be useful. It has to have some use. And I guess you can argue the aesthetic nature of it is a use. And then it has to be a non-obvious improvement over what's already out there. And that's pretty much every patent comes down to obviousness. That's the big hurdle that you have to overcome.
I've never seen that pink thing, just so that you know. All right, Vincent LoTempio, thank you very much. We really appreciate it. For more information and answers to your questions, contact Vincent LoTempio by calling 716-216-5000 or go to lotempiolaw.com. Sponsorship and promotional considerations for the preceding segment was provided by Vincent LoTempio. And you can start your weekday with me, 7 to 9 a.m. on The Big Wack.